Hello, welcome to a presentation on Montana's Governmental Code of Fair Practices by the Montana Human Rights Bureau. So what is the Governmental Code of Fair Practices? The Montana Human Rights Bureau enforces both Chapters 2 and 3 of Title 49 of the Montana Code. Chapter 2 is the Montana Human Rights Act, and Chapter 3 is the Governmental Code of Fair Practices, which both prohibit unlawful discrimination. But the Governmental Code of Fair Practices specifically prohibits state and local governments from discriminating based on a protected class. It imposes certain obligations on governmental entities and, in a way, sets a higher bar than is expected of the private sector. And this makes sense considering the government's function and service to the citizens of Montana. The state has an interest in eradicating unlawful discrimination, so it should set the example. And speaking of unlawful discrimination, let's take a moment to remind ourselves what that means before we move forward with looking at the details of the Governmental Code of Fair Practices, or GCFP, because this definition still applies when we're talking about discrimination under the GCFP. Unlawful discrimination is when an adverse act is taken against an individual because of their protected class status, and the act must be taken in a protected area. So let's look first at what the protected areas are under the GCFP. The first protected area is government employment. So the GCFP protects government employees from unlawful discrimination from their government employer. Public education is also covered under the GCFP. So this means elementary schools, junior high and high schools, and colleges and universities are all covered so long as they're not private institutions. The other protected area concerns the actions or services of state and local governmental agencies. The concept of governmental services is pretty broad, and it tends to be anything the government does for the benefit of an individual. The examples listed here on this slide are from cases filed at the Bureau. This is not an all-inclusive list, just a few examples to give you an idea of what we see here and what would fall under this protected area. The examples include duties performed by staff at correctional institutions for the benefit of inmates, investigations of reports of abuse or neglect made to the Child and Family Services Division, self-help family law centers located within our courthouses, legal representation by the state's public defender, and services through the Motor Vehicle Division to obtain licensing and identification. And here you see the protected classes under the GCFP. The protected classes are any age, sex, including biological sex, pregnancy, sexual orientation, and gender identity, race, color, national origin, religion, creed, disability, marital status, vaccination status, and political ideas or belief. Political ideas or beliefs is only found as a protected class under the GCFP. It is not included in the Montana Human Rights Act, so it is not applicable to all protected areas, just the protected areas under the Governmental Code of Fair Practices. Political belief is a publicly shared stance on issues of public concern. It is much broader than just party lines or party affiliations. As an example, the Bureau investigated a case in which an individual asserted she regularly participated in city council meetings advocating for government transparency. When she later was passed over for a job by the council, she asserted they failed to hire her based on her political belief. The woman's publicly shared stance on government transparency placed her in the protected class of political belief. Another case was a public defender who spoke out against the state's plan to centralize the public defender system. Her vocalization of her stance on this issue of public interest placed her in the protected class of political belief as well. As mentioned before, the GCFP applies to state and local governments. But what does that entail? Who does the GCFP apply to? The GCFP applies to any branch, department, office, board, bureau, commission, agency, university unit, college, or other instrumentality of state government, as well as all county, city, town, school districts, or other unit of local government, and any instrumentality of local government. The GCFP has various parts within the statute that specifically outline the acts a governmental entity must do free of unlawful discrimination. Sometimes the GCFP requires the governmental entity to perform certain acts to ensure it is complying with the GCFP as well. The types of governmental acts covered by the GCFP include employment, employment referrals and placement services, educational, counseling, and training programs, licensing, governmental services, distribution of governmental funds, contracts, public accommodation laws, and retaliation. We will now go over the ones more commonly seen in better detail. As mentioned earlier, the GCFP prohibits discrimination against government employees. State and local government officials and supervisory personnel are required to recruit, appoint, assign, train, evaluate, and promote personnel on the basis of merit and qualification without regard to a person's protected class status. Note that the statute specifically says that state and local government officials and supervisory personnel must perform these acts free of unlawful discrimination. The way this part is worded means that such supervisory personnel who violate this part can be named individually in a complaint. This is a bit different than most complaints, which are only filed against the entity as a whole rather than individuals alleged to have discriminated. Typically, the Bureau will see cases filed by sheriff's deputies after an election because they feel they're being treated differently because they publicly supported the sheriff's opponent. Often these types of cases are filed against not only the county where the sheriff is located, but also against the sheriff personally and sometimes other supervisory personnel involved in the employment decisions. Under this part of the GCFP, concerning government employment, the governmental entities have a duty to maintain discrimination policies, review the policies and practices to ensure compliance, and conduct ongoing training programs. A failure by the governmental entity to carry out these duties is a violation of the GCFP, apart from any specific instance of discrimination occurring. So governmental entities should set up some type of protocol or manner of making sure on a regular basis that policies are in place, the policies are being reviewed, and training is being completed by employees. The governmental entity should also make sure it is documenting the completion of these tasks. So the state and local governments cannot discriminate against their employees. But the GCFP also says they cannot discriminate in the way they perform services either. We talked about governmental services earlier when we went over it as a protected area. It is very broad and basically includes any type of service or function of the government that is done for the benefit of an individual. And as the examples provided prove, the service or benefit doesn't even necessarily have to be something desired by the individual, as it includes pat-downs of inmates and DPHHS investigations into reports of abused or neglected children. How law enforcement treats someone pulled over for a traffic violation would also fall under the protected area of governmental service, and this part we are discussing under the GCFP. The government must perform these acts without any discrimination. This part also prohibits government facilities from being used in furtherance of a discriminatory practice or a governmental entity from being party to an agreement, arrangement, or plan having the effect of sanctioning or allowing a discriminatory practice as well. Similar to the part under government employment, governmental entities have an affirmative duty under the GCFP to review operations to identify places where services may be performed in a discriminatory manner, and also to engage in programs that remedy defects found during the review of operations. The GCFP also has a specific provision prohibiting discrimination in granting, denying, or revoking a license. Also specifically under this part, the statute clarifies that DPHHS can still license a faith-based agency that considers certain religious factors in adoption proceedings. There is also a subsection here that strictly prohibits the state from issuing or renewing a license for the sale of alcohol if the licensee discriminates. However, there is an exception for a lodge of a recognized national fraternal organization. They can still be given a license for alcohol even if they exclude people from membership based on a protected class, such as sex. Like government employment and governmental services, the government has an affirmative obligation to take appropriate action when exercising its licensing or regulatory power to first, ensure equal treatment of all persons, second, eliminate discrimination, and third, enforce compliance with the GCFP. Government contracts are also covered under the GCFP. Whenever a governmental entity is contracting for goods, services, public work, or the construction of public buildings, the contract must contain two specific provisions. The first, that the persons performing the contract will not engage in unlawful discrimination, and the second, that all hiring will be based on merit and qualification. Governmental entities are also prohibited from retaliating against individuals who engage in protected activities. Protected activities include objecting to or opposing discrimination, participating in a complaint or investigation into discrimination, and typically requesting an accommodation. Governmental entities cannot take an action against you meant to dissuade you from engaging in protected activity again. Based on cases seen here at the Bureau, we do have some tips and suggestions. First, we suggest you read through the GCFP. Next, if you are a government employee, understand your responsibilities. Are your policies in place? Are you reviewing them and your operations regularly? And are you conducting necessary training? And last, understand the difference between using non-discriminatory employment practices and providing governmental services in a non-discriminatory manner. You should now have a general understanding of the Governmental Code of Fair Practices. If you'd like to learn more, visit our website at www.montanadiscrimination.com or give us a call toll-free 1-800-542-0807 or 406-444-2884.